Barratt.
Well, Mr. Greatorex, you're unopposed, but the other side are holding the judgment, so you have to persuade us that the Court of Appeal were wrong.
Well, I'm grateful for that indication, my lord. I was going to begin my submissions with a gentle inquiry along those lines.
Yes.
Mainly because it's a slightly unusual hearing in the sense that nobody is going to be opposing me here. And I haven't had the benefit of a skeleton argument knowing exactly the points said against me in advance. I wonder whether it would be helpful for me to inquire if there's any particular matter that it would be helpful for your lordships and your ladyship to address, for me to address you on.
Well, I think if it's, perhaps I can put it this way, that you, as I said before, you have to persuade us that the Court of Appeal were wrong, and you have against you a judgment. Of course, it's a majority judgment, but very experienced Lord Justice delivering the main judgment, and a rule which apparently has been uncontested for 30 years, and so on. So I think the best thing for you to do is to proceed along the lines of your written case and address us as you were going to do by reference to the statute, the various provisions that you ask us to look at, and what we're to make of the authorities. So you should assume that we're looking at this very closely, and you shouldn't assume that we're necessarily in your favour.
My lord, I'm grateful. In terms of why the appellant says that this appeal should succeed, it is either on the wider or the narrower basis that's advanced in the appellant's case.
Yeah.
The wider basis is a root and branch attack on the rule in Brown, as I shall call it for convenience in this hearing. It's sometimes referred to as the rule in Brown and McMaster, but as I will take the court to shortly, I think it's a mistake to assume that the rule is exactly the same in both of those cases. Brown has a very clear ratio, McMaster doesn't. But for shorthand, I shall call it the rule in Brown. So we say that's wrong, and Lord Justice Lloyd in the Court of Appeal was right. That's what I call the wider basis. And then there's the narrower basis, if I can call it that for convenience, which is to say, well, even if that rule is basically right, and perhaps I should articulate what I mean by the rule, i.e. that the effective date of termination under Section 97 is when the employee reads the letter of dismissal, or at least has had a reasonable opportunity of reading it.
Yes.
Even if that is to be broadly to remain the law, then it needs to be qualified, for want of a better expression, or better explained. And the facts of this case demonstrate in my submission very clearly a misapplication of that test, or at least an application of that test that should not be upheld, even if the broad principle of the test.
She should have rung home to find out whether the letter had arrived and got somebody to read it over the phone to her.
In short, my lady,
Yeah,
yes.
that's your argument, isn't it?
It is. But the way I've put it in the written case is slightly different. What we say is that reasonable opportunity, if it's to be upheld, must be given a much narrower construction. And it does not mean that the question of whether or not the employment tribunal has jurisdiction, because this is a hard-edged question of jurisdiction, does not or should not depend upon an assessment of the reasonableness of the employee's actions between the point of delivery and the point of reading.
Well, we'll come on to examine that point after the first one, will we?
Well, yes.
You're going to take the
wider point first.
The head-on point, yes, about the rule in Brown first.
That's right. But, my lord, I was just going to say one more line about the narrower point to round off the submission in summary, which is that, and I said this is why the facts of this case illustrate this, it is quite clear that the employment tribunal judge was heavily influenced by his view that the trip to London was completely understandable and reasonable because of her personal family circumstances. You'll recall that her sister had a baby in circumstances where she'd previously lost one. That seems to suggest that if she had, for example, gone to London for a weekend of partying, or some reason that perhaps didn't command the same sympathy of the tribunal judge, the outcome might have been different. And we say that that can't be right. But, my Lord, going then to the wider ground first, the rule is, as I said, best summarised in Brown as being that the date on which the termination takes effect in section 97 is the date when either the employee does read the notice of dismissal or when he reasonably had the opportunity of knowing about it. And one can immediately see that even within that rule, the concept of what has been called in other cases, for example, constructive knowledge, where it's been suggested, and McMaster said constructive knowledge plays no part, does in fact have a part. It's quite possible that an employee can, the EDT can come around without the employee knowing about it because the employment tribunal judges some 3 or 6 months down the line that he or she had a reasonable opportunity of finding out about it before they did.
Could one start at the other end, though? I mean, the employer has an option in these without notice cases, doesn't he? I mean, he can simply announce the decision to dismiss straight away.
Yes, my Lord.
I mean, there is a choice there. So, I mean, if he does that, there is simply no question. I mean, the date of termination is absolutely plain as could be. So, in deciding to hold his hand and do it by letter, he's opting for an alternative which may suit him, but one has to consider very carefully the effect on the employee. And I think you would accept that as well, wouldn't you?
I would, my Lord, and it'll be a theme of my submissions that one must, and in fact it supports my case, that one must look at this matter both from the perspective of the employer and the employee. And one of the arguments that's mentioned in my written case is that at the moment there seems to be an asymmetry, certainly in the decisions of the EAT, between what employers have to do and what employees have to do in order to bring about the termination of a contract of employment. And I'm sure your Lordships know the point I'm talking about. If one looks at the cases of Potter and Temple and George and Luton, they were cases where it was resignation by the employee. My essential submission on this is that the law should be the same for both. That's
Why?
First, my Lord, for the simple, what on the face of it is a simple rule, a simple submission that the rule should be the same for both sides. And secondly, and this relates to another main theme of my submissions, that it is more productive of certainty for everybody if the rule is the same across the board. It's often helpful because employment cases are often intensely practical decisions, and that can sometimes lead to difficulties in extracting clear threads of principle. But the case that perhaps best illustrates this need for balance and fairness in the bundle of authorities is the case of Potter and Temple, which is at tab 15 in the bundle of authorities. And if your Lordships begin on page, with paragraph 4, I'm afraid the pages aren't internally numbered, which I apologise. There's a reference in paragraph 10 to this case being argued through the looking glass, and the reason for that reference is because what happened, as recorded in paragraph 4, is the employee had a conference with his solicitor, and that night a faxed letter of resignation. And paragraph 6 asks the question, why did the solicitor do that? The tribunal found that Mr. Potter had been told there was a letter in the post to him suspending him, which he expected to receive on the Saturday morning. Dismissal and possibly suspension were reportable events to the Financial Services Agency with whom he was registered. He wanted and intended his resignation to be received by the company before he received written confirmation of his suspension and before any other disciplinary action could be taken against him. And the reason why in paragraph 10 the tribunal said it was through the looking glass, because by the time this case came around, he was arguing the exact opposite, because otherwise his claim would have been out of time. But, my lords, my lady, that's a concrete illustration of an example where an employee may well want to effect immediate resignation and have very good reasons of their own, even if objectively one has one's doubts about the propriety of it, wanting to effect a resignation without any delay, and the rule in that case was applied in the employee's favour.
Lord Justice Mummery comments on this case in paragraph 40 of his judgment.
Yes.
I think that he's grouping these various cases as being cases not directly in point, but supporting the idea that the date is not necessarily the date yielded by contractual analysis, and emphasising the importance of certainty.
Yes.
Favouring, as I think his judgment really goes, favouring the employee, because he regards the employees in a particular position because of the personal nature of the contract and the comparatively weaker position an employee is in compared with the employer.
Well, my lord, that of course is right when one thinks, for example, of a classic example of a very large employer with a large and sophisticated and well-resourced human resources department and an employee who may not have any particular grasp of the niceties of employment law or contract rules. There's a clear imbalance there.
Yes.
But of course that's not always the case. And one has to be very, very careful in my submission about approaching employment law on the basis that it is designed to redress a balance which exists between monolithic employers who hold all the power and the cards and helpless employees who are at their whim and mercy. There's two reasons why that's not right. Is one, in terms of the size of employers and the wherewithal of the employee, that can vary enormously. My clients, for example, are a very small charity. One can have a single employee who's a one-man business who employs one other person to help him or her run it. One may have an employee who is independently wealthy, even if in a not a particularly well-paid job, who has access to expensive lawyers that an employer, for various reasons, might not. So approaching the matter on the basis of a stereotypical view of an imbalance between employers and employees is unsound as a matter of fact and practice. And in any event, it must be questionable how far, even if one accepts that will be the case, maybe even the majority of the time, that should influence matters of principle. If it is to be the case that there is a different law for employers and employees, then the matter should be made clear. And one thing that will come out of this decision, whichever way it goes, I'm sure, is clarity which I think the Court of Appeal were unanimous doesn't really exist at the moment. Part of that results from the fact that the matter hasn't really been decided above the level of the EAT since the rule was first laid down in 1980. And my lords, to the extent it has, and I'm thinking in particular of the Radetzky case, Kirklees and Radetzky, which your lordships and your ladyship will have seen from the written argument, does at least pose a problem and requires some sort of explanation, because it's not compatible with a fundamental principle, if there be one, that an employee cannot be dismissed without knowing about it or having any means of knowing about it, because there the Court of Appeal upheld a finding that Mr. Radetzky's employment had come to an end at the end of October, notwithstanding he didn't find out about it until at the earliest 2 weeks later. The same might be said of the Clark case. Even Lord Justice Lloyd, whose judgment in the Court of Appeal is supported by me, wasn't with me on this particular point. He was, I don't mean this pejoratively, he was rather dismissive, taking the view that it didn't really assist in this situation. But the fact remains, it's a judgment of the Court of Appeal where the employee in question was found, his employment had come to an end, regardless of any consideration of whether he knew or could have found out about it. So the starting point in my submission can't be in dispute and wouldn't be in dispute were the case of the respondent being argued, that the law is in a state of some confusion and there's a lack of clarity. And it is part of the first step of addressing that lack of clarity that I make the submission that the rule should be the same for both parties. Because, my lord, what has been consistently said, and this goes back to the, I think the Deadman case, well, I think it's the Robert Court case, which we'll be coming on to, but it's generally been accepted that what is desirable, so far as possible, is certainty.
Well, Lord Justice Mummery makes that very point in paragraph 40.
Yes.
Indeed.
Well, my lord, I didn't address you any further on paragraph 40 because one of the slight problems with paragraph 40 is that it doesn't sort of say anything concrete. It's a brief discussion of the cases, which is preceded by the observation that the cases are not directly in point. So paragraph 40 doesn't offer in my submission, any real insights into Lord Justice Mummery's thinking or reasoning. It's more a brief narrative summary of the cases mentioned there.
Do we get more then from Lord Justice Lloyd in paragraph 49, who does devote a full paragraph to the case?
Yes. Well, my lord, again, paragraph 49 is a summary of what the case says, which is very convenient to save one having to read the whole thing. But the point that's made by Lord Justice Lloyd, relying upon that, is, and I think one finds that in paragraph 75.
Yes.
Is essentially the submission I'm making, which is that the decisions of the EAT are not altogether as consistent as might have been thought. Brown and McMaster are broadly consistent, although not identical in their detailed pronouncements, as I've already indicated. Potter, however, seems to me to be inconsistent. George is not inconsistent since it proceeded on the basis that delivery to the council's offices, where the letter was opened on the same day, was sufficient delivery to the employer. Well, while we're looking at that, my lords and my lady, the only observation to be made about that is that insofar as there is any suggestion that the concept of constructive knowledge is one that the law should shy away from in this area, one again sees that is effectively, whether one calls it constructive knowledge or gives it another label, nobody at the council, being a big organisation, who had anything to do with the employee, there's no finding that they knew about the resignation. It was received by the council in the same way that the telex in the Brimners was received. But nobody had applied their mind to it, or nobody with any relevance to the employment relationship or in the Brimners to the contract, the Charter Party, had seen it. So whilst not having received permission for this appeal to then downplay the importance of the point, because it is a point of general public importance, one also has to bear in mind that it does have potentially, at least, depending upon the court's decision, a relatively narrow scope. it would be possible to say that anything that this court says as a result of this appeal is confined solely to Section 97 and can have no bearing or application to the wider issues that may arise upon termination of a contract, such as, was Miss Barratt in this case, to take an example, entitled to be paid up until the Monday when she read the letter? In terms of pounds and pence, it would be a very small amount either way. But the point of principle is still there. There may be issues such as benefits. I don't think it's entirely fanciful to imagine a scenario where, for example, there's private health insurance and an employee falls ill in the interregnum, as it were, between delivery and reading. And the point is at the moment, what both employees and employers are forced to do, even if one's just looking at the statutory EDT, may be forced to do, is to go all the way to tribunal and have a hearing in order to determine the question. And that's really the starting point for my attack on the Brown Rule. But that's not in anyone's interests. It's not in the interests of employees to have litigation where it can be avoided. If one had a very clear rule that enabled employers and employees, and perhaps most importantly, perhaps I shouldn't say that, but also those representing them, who have the job of advising them, and also doing the practical job of lodging claim forms in time and so on and so forth, have no doubt at all about what the relevant time limit is. And what we're talking about, of course, here, as I've said in the written case, is a situation where some time has elapsed. This is effectively a retrospective exercise. By the time one comes to fill in your claim form to the employment tribunal, it will be some weeks, if not 2.5 months, or 2 months and 29 days, as is sometimes the case, before the time of the dismissal in general terms. So, in my submission, it isn't a relevant consideration, or the court should not be distracted too much by the idea that an employee could be on day 2, to use my example, or day 3, thinking they're an employee, when in fact they're not. Because that's not really what this appeal is about. We're talking about when one sits down afterwards to decide when the time limit is for putting in a claim, and when there's a potential dispute about whether it's in time, is there a clear answer to that, or does everyone have to troop off to the employment tribunal and have a hearing in front of a judge where concepts such as reasonableness, with all the scope that brings with it for disagreement of views and difficulty of predicting what a tribunal judge will say, come into play? So my starting point is the unsatisfactory nature of the way that this rule in principle and in practice.
Yes. Well, is it helpful to go back to the beginning and look at the statute and take the 1996 Act as the starting point, although, of course, the history takes us further back still. But we can look at the 1996 Act, can't we, and see just how the expression is used, to see whether there's any guidance from the statute itself, because, I mean, so far you're saying the authorities are inconsistent and therefore there's a lack of clarity. Something must have gone wrong, you're saying. I'm suggesting we look back at the statute and see whether that helps.
Well, my Lord, I have to say I'm not sure there is an enormous amount of assistance to be derived, but I think what is important, and while I'll go through what I've said in my written case about it, is to look at what the effective date of termination matters for within the Act. I think unless the court would rather look at the original provisions in the bundle of authorities, it's most conveniently set out in my written case, starting on page 2. But for cross-reference, it's tab 1 of the authorities bundle is where the provisions are set out.
Well, it's perhaps helpful to look at the provisions in tab 1 just to see how they're set out in the statute.
Yes, of course. My Lord, the first section in tab 1 is the rights of employer and employee to minimum notice. That isn't actually relevant to this point, because this deals with the point that I mentioned in the written case about when, for limited purposes, the EDT can be extended. It may well be we come back to that. if the court turns over the page, section 92, and unfortunately doing it in this way doesn't take matters in order of importance. It's in order of chronological, the sections in the Act. The right to written statement of reasons for dismissal is not something I think is going to carry much weight in either, in any event. But to have the right to a written statement of reasons, you have to have 1 year's continuous employment.
So it's subsection 3 you need to look at to see whether the employee is entitled to a statement. So you would say certainty is needed, otherwise you're left in doubt as to whether or not the employee is entitled to a statement.
Well, that's right, my lord, although I really would not like to try and overstate the importance of this. Generally, unless one has 1 year's continuous employment, one doesn't have the right to claim unfair dismissal. And as I said, the written statement of reasons for dismissal is not a provision that, if I may offer the observation, comes up very often in practice.
Right.
But, my lord, yes, the right only arises unless you've had 1 year's continuous employment on the effective date of termination. But as I said, you won't have the right to claim unfair dismissal unless that's the case anyway. The next section, which, if it assists, there's pagination in the top right-hand corner, following the way it was printed out, page 3 of 18. This is the key section, the effective date of termination. And 97(1)(a) is termination by notice, which is not the case here. It's B, which is the case here. An employee whose contract of employment is terminated without notice means the date on which the termination takes effect. And then C deals with fixed term contracts, and there's an amendment there, as the court can see. Means the date on which the term expires. Well, the only observation I would make about this section is that it's classic, as Lord Justice Lloyd said in my submission, it's Parliament's language clearly leaving the matter to the courts. When the termination takes effect.
Yes, so it's a statutory creature. As I think Lord Justice Mummery was saying, it's essentially a statutory construct.
Well, that's right. My Lord, the point I forgot to make earlier when saying it depends on the court's decision. It may well be the court is very keen, depending on the decision, to confine whatever it says simply to the statutory construction of section 97, and to say it leaves open the question of whether wages have to be paid and so on and so forth. But the submission I wanted to make about that, which I'll probably come back to at some point, is simply to say that it would be undesirable to have different rules, all other things being equal. Now, of course, it may be that all other things are not equal, and therefore the best way is to have two different rules. One very clear one under section 97, and then perhaps leave everything else open to be argued on a case-by-case basis. But, as I said, if it can at all be avoided, it would certainly, and for everyone must be able to agree on it, it would be preferable to have a rule that is applicable in different situations, rather than deliberately introducing one rule for one and one rule for another.
So if the Court of Appeal's decision is upheld, you would invite us to make clear that the consequential benefits to the employee would endure until the effective date of termination.
No, the opposite, my lord. The opposite. Because I think if we are to lose this appeal and the rule is to be confirmed that the effective date of termination, at least for section 97, and the 3-month time limit only starts to run when the employee reads the letter of dismissal, that's going to cause, obviously, it's going to perpetuate the uncertainty from an employer's perspective, being able to calculate that. My submission is that this court should not leave any scope for employees to argue that as a result of that decision, if it be this court's decision, an employee is also entitled to all other contractual benefits up until the point when they read the letter as well. Because whilst it may be one thing to expect employers to put up with a bit of uncertainty and perhaps lose employment tribunal cases about whether claims are in or out of time, in my submission it would be quite wrong, and I think this would actually be new law because there's no decided authority actually confirming this, to say that employers are bound to pay employees and give them all their benefits to which they're entitled under the contract of employment up until the moment when they happen to read the letter.
Well, that then has to be decided on a case-by-case basis, does it?
Well, I think, my lord, I certainly wouldn't invite you to say that in this case because it would, as I said, I think that would be quite possibly breaking new ground for the law to say that in those terms, and that would be a decision that would have a very serious impact on employers.
No, I'm sorry, I didn't make it clear. Your submission is that we should not say that if the effective date of termination is the date on which it would be reasonable to expect the employee to read the letter, we should not say that she would automatically be entitled to wages, salary, any benefits and so on. And that should remain something to be decided on a case-by-case basis.
I think that's right, my lord, because I don't think it would be appropriate for this court to even try and give guidance on that. My primary submission, as I said, is that you should not deliberately introduce this dichotomy.
No. But I'm just interested to explore that you're willing to sacrifice certainty in that context.
Well, I think, Lord, forgive me for interrupting, I think I would probably more frankly put it as I want to keep, on behalf of my client as an employer, the employer's powder dry to argue on another day that, notwithstanding this decision, if it be your conclusion, a different approach should be applied to the payment of pay and benefits.
Well, does one not stick to what the statute is telling us? The statute, please correct me if I'm wrong, but it doesn't actually say anything about the right to payment.
No.
So one would assume, if it hasn't entrenched on the ordinary law of contract, that if the employer is deciding whether or not there is an entitlement under the contract to continued payment, he looks to the law of contract for that, unless the statute says the contrary. But the issue we're faced with, looking at Section 97, is that we've got a definition of an expression which is not commonly used in the law of contract. It's a statutory expression which is injected into the statute for particular purposes.
Yes.
So one has to take it, I suppose, that there are two systems at work here. One is the contractual, which applies unless otherwise provided for by statute, and then there's a statutory system which is there to regulate redundancy payments and the appeals against dismissal and so on and so forth for very particular issues which are dealt with under the statute.
Yes. My Lord, that is right, but what I'm simply trying to indicate is that it's entirely conceivable, particularly depending upon the wording used in any decision of this court, that a decision on Section 97 will be used as a basis for an argument that actually is not confined to Section 97, and if the effective date of termination is whenever the letter's read, then it must follow from that not only do the 3 months start running from that date, but you're also entitled to your pay for that date. And while I'm not aware of any decided case, or for what it's worth, any case in practice, where that point has been run. And it may well be that the difference is in fact so small in terms of a number of days' pay that will explain why the matter never goes anywhere. But it's easy to imagine in my submission a case where that could become highly significant.
But the logic in any event of the current state of the law is that this is a statutory regime which was designed to introduce new remedies for employees, and we have to construe the statutory regime, and there's this long-standing authority construing it in a particular way, precisely saying that it isn't governed by the ordinary law of contract. Whereas, of course, entitlement to pay and benefits is, as we have established, governed by the ordinary law of contract. So it's in a different box, isn't it?
That would be my submission if I were defending a claim for unlawful deduction from wages in that situation in front of the employment tribunal. Yes, my lady, but the contrary could not be ruled out. I'm simply drawing it to the court's attention because if the expression were to be used that the contract of employment endures until the letter is read, or some phraseology were used unguardedly, then that's a possible consequence would be seized upon, or potentially seized upon. But my primary submission is that one should try and keep the statutory construction as close to ordinary principles of contract as one possibly can. That should really be the starting point. And in my submission, that also really seemed to be the view of Lord Justice Mummery. He seemed to accept two things, really. First of all, that the contractual analysis was as we say it is. And second of all, that provided the starting point. But what he went on to say...
Paragraph 33, he says, as you rightly point out, he says the contractual analysis is certainly possible as a starting point.
Yes.
But it doesn't follow. He then goes on to say that the correct construction of the statute is controlled by contractual considerations. So he then gives various reasons why he takes that view, and he's departing, as I read it, I must say, from the contractual standpoint at this point and looking more at the purpose of the statute and the effect of it.
Well, yes, my lord, I wouldn't try and make too much out of saying that it was accepted, it was the starting point from which it has to be departed, but it's interesting that he uses that, and then if one looks at the reasons, certainly the structure of his judgment is to say these are the reasons why I don't think it's right to do what would otherwise, or come to the same conclusion as would otherwise be the conclusion if one applied the contractual principles. I think really all I'm submitting at this stage is that may well be right ultimately, but it would be desirable from everyone's point of view, employers and employees and tribunal judges and lawyers, if we could get to a situation where they were as close as possible, rather than deliberately introducing a dichotomy.
Well, we were working our way through the statute.
We got so far on page 5 of 18, section 108, which is one of the most important provisions in the Act because it provides for who can and can't claim unfair dismissal. And it requires continuous employment for a period of not less than 1 year, ending with the effective date of termination. My lords, my lady, in parentheses only, and the reference is in my written case to paragraph 19 and footnote 19, that can be extended. This doesn't really matter, that's why I say it's in parentheses. But where an employer sacks someone within the final week of their first year of employment and claims that he or she does so because of gross misconduct, then the question of whether or not that person can claim unfair dismissal depends upon whether the employer is right about the employee being guilty of gross misconduct. Because if the employer is not right, then section 86 provides, and that was the first section we looked at, section 86 provides that the notice period is what you were entitled to under statute, so that's 1 week, and that would take the person over the 1 year. But that doesn't apply to the 3-month time limit, which we're going to look at in a moment. So even if a dismissal is wrongful, to use the correct terminology, you might get your extra week's notice for the purpose of pushing you over the year if that makes a difference, but it doesn't make any difference to the EDT for the purposes of section 111 and calculating the 3-month time limit. Unless there's anything more on that section, the next section is on page 10 of 18.
Section 111.
That's right. And this is, again, a very important provision, very well known. You have 3 months to claim of unfair dismissal. In layman's language, in terms of the statute, the claim must be presented to the tribunal before the end of the period of 3 months, beginning with the effective date of termination. That's subsection 2A. And then B contains the extension provision, which there is no dispute, has always been construed strictly where it was not reasonably practicable for the complaint to be presented before the end of that period of 3 months. And the court will recall that in this case, the unchallenged finding of the tribunal was that it was reasonably practicable for the claim to be presented within the 3-month time period. This provision is very important because it provides the key safety net and answers, in my submission, a lot of practical concerns that might otherwise arise about a delay between a dismissal letter being delivered to an employee and being read by the employee.
Safety net for whom?
For the employee. So if the employee, the letter is delivered and the employee has gone away for a lengthy holiday or is in hospital, what we say, the way this section addresses that, is the EDT is still when the letter was delivered, but it may well be that because of the hospitalisation or because of the holiday or because of whatever it is that's relied upon, it's clear that it was not reasonably practicable for that employee to present their claim within 3 months.
Well, take an example of what could happen. The house may be unoccupied when the letter is delivered, and normally there isn't a date of delivery on the letter. I mean, one could have that, but not necessarily so. And if one examines one's mail when you return, you've no idea when the letter was actually delivered. How is the employee to work out, if you're right, what the date is?
Just to remind you, my lord, that Lord Justice Lloyd does mention this briefly in his judgment. Perhaps I'll go to that in a moment. I think that is unlikely to cause difficulties in practice for 2 reasons. One, because unless we're talking about a very lengthy absence from home, almost up to the point of the 3 months, then an absence of a week or so is unlikely to make a huge amount of practical difference to the employee because they still have 3 months. And I'll be addressing later Lord Justice Mummery's point about Parliament intended employees to have a full 3 months rather than anything less. But just for the moment, looking at whether this is likely in practice to be difficult. The second point, I think this is mentioned by Lord Justice Lloyd. Again, there will be a postmark on the letter. They're not always legible. Of course, I accept that. But the letter will have a date on it, one presumes. And so if an employee is being prudent or his advisors are being prudent, then it is not an unreasonable imposition to expect an average employee to assume that the letter was delivered within 2 days or 3 at the most of the date on the letter. And again, in the context of 3 months, that is not significant in my submission.
I think many of us have got experience of inaccurate dating on letters resulting from the curse of the word processor.
Yes.
In my experience, over a long life. It's got a lot worse recently.
Well,
Postmark may be more reliable than...
Yeah, quite, my lady. Can I mention two other practical matters? One, in the sort of the scenario that we're talking about, certainly here, it is extremely unlikely, if not inconceivable, that the letter will be coming out of the blue, because the employee will have attended a disciplinary hearing. They will have received a letter in advance saying your continued employment is at risk, or they should have done, or it will have been apparent to them. I mean, certainly on the facts of this case, they're fairly extreme, because there was a finding of fact based upon what the respondent herself said, that she was very keen to know the decision and asked specifically when will it be being delivered. And it was delivered exactly when the employer said it would be. And then the final matter, which of course I think if one is looking at the practical side of things, one can't leave out of account, is the fairly obvious and easy option of the employee contacting the employer. Certainly if it's come out of the blue, one would expect that in any event. Have you sent this letter by mistake, for example, or what on earth is going on? But again, if one's looking at the practical side of things, and even if one is concerned not to lay down a rule that is going to operate to the disadvantage of ordinary employees up and down the land, one has to remember, one's not talking about children. They may well have to get in touch with their employer for matters in any event, such as references, sorting out their P45, any number of matters that might arise on the termination of an employment relationship. And if there is any genuine doubt at all, first of all, and second of all, if that doubt is material, because one is up against the 3-month time limit, then one would expect, reasonably in my submission, that an employee could raise that. If I just may at that point do what, in my submission, one has to do at every stage of this when one's talking about either the employee or the employer, is to turn it round and look at matters from the other perspective. Whilst matters may be different, I accept if the employer knows something about the house being empty or the employee going away. One also has to question the practical fairness of a rule that leaves an employer in a state of uncertainty, even though they've acted perfectly properly and reasonably and done everything they could be expected to do to bring the matter to the attention of the employee. Again, these facts of this case provide a very, very clear example, because the employee had specifically asked, when are you going to send me the letter? I'm particularly keen to know the outcome. And the employer said, told her what it did, and did exactly what it said it was going to do, and everything so far as it was concerned happened.
But of course there will be quite a lot of cases, won't there, where there might be quite a considerable time lag between the disciplinary hearing and the employer's decision.
There may be, my lady, yes.
And the employee may not know what's going on.
Well,
Or go away.
that is right, my lady. But as I said, when in the part of my written case, which I'll come on to, where I deal with the rule or the alternative rule that's effectively I'm arguing in favour of, if one tests that against those practical considerations, in my submission, the court will see that it is sensible and workable and does not cause prejudice in practice. We got onto this by way of looking at the reasonably practicable exemption, and my submission is that it is very important that that is there, because it does deal with a delay which is significant, if it makes it not reasonably practicable. Then that is the safety net there. So the idea that an employee could be in a coma, for example, and not know about it, or be otherwise hospitalised or out of the country unavoidably, and it was simply not possible on the evidence within the 3 months to put a claim together, then that is there. But of course, what one has to remember in a lot of these cases, this case as well as others in the bundle, is that they come before the court sometimes, as in this case, where there has been some default on the part of the legal representatives. We know that in this case because of the findings that were made. The employees' representatives were under a misapprehension about when the effective date of termination was nothing to do with the provisions we're considering here. It was all to do with the grievance procedure rules, which were terribly complicated and have now been repealed, but operated in certain circumstances to extend the time for presenting a claim beyond the 3 months. And that's what they thought had happened here. In the case of Potter, for example, which we looked at very briefly, the employee was very, very anxious to send his resignation in by fax on the Friday evening. Then when it turned out 3 months later that he put his claim in a day too late on one view, then he was very anxious to argue the opposite. Again, one comes back to my submission that this is a practical situation, and what is most desirable is to have a clear rule that when one's sitting down in retrospect is clear to apply and doesn't require adjudication by a tribunal or any doubt on either side. One's not concerned, as I've said already, with practical considerations about on day 2 or day 3 or day 4, because as the exchange earlier, as I was making clear in the exchange earlier with my Lord Carr, that the position with regards to pay or other obligations under the contract of employment may be entirely different.
There is an opportunity to appeal against the dismissal, which was taken in this case, wasn't it? And I think the appeal was heard actually very promptly, within 2 weeks, 2.5 weeks or something. But there could be cases where the appeal actually doesn't take place, isn't heard for quite some time. How does that affect the problem? I mean, your time is running against you, of course.
Yes. Because
the 3 months dates from the EDT, not from the date of the determination on the appeal.
Could I have one moment, my lord?
Yes.
Well, I was just confirming. The test of reasonably practicable, as I understand it to be applied, I don't have authorities to hand, but is that the tribunals would not normally see the fact that an appeal was pending as meaning it wasn't reasonably practicable to put your claim in within the 3 months. So if one is dismissed on the 1st of January, one has until the end of March. And the fact that you might have an appeal at the beginning of March, say, or even the middle of March, does not mean that it's not reasonably practicable for you to put your claim in.
No, so time is still running against you, because that's what the statute says. Yes.
It's a very narrow test, the reasonably practicable extension.
Yeah. But then one puts oneself in the position of the employee who's got to take the initiative of making the complaint under the statute. The employee has to have a date reasonably certain to him or her to work to. And the longer the time, I mean, it's understandable that the employee would wait until the appeal had been determined before deciding to actually make the complaint.
I'm sure they would if they could, but
yes.
If they had to choose one or the other, they'd be negligently advised if they weren't told to put the claim in and then withdraw it if they're reinstated on appeal.
See. Is there anything more on section 111, or should we move through the statute a little further?
No, there is not, my lord. 119 over the page 12 of 18 is the basic award, and again, when I was being frank, one has to put this in a category of not being so important. It's not going to make a huge amount of practical difference.
No. Because
the most it's going to do is to deny you 1 or 1.5 weeks pay.
Well, it's all a question of calculation. It doesn't greatly matter. Nobody's particularly disadvantaged one way or the other by whatever date you take, provided the arithmetic is properly done.
Well, that's right. So I don't think that there's much assistance to be gained from that, nor are there any practical considerations arising out of that section that would influence the matter one way or another. The same is not quite so of the next section, 128. can I summarise it for the court in general terms? It's applications for interim relief. It's a very unusual and narrow category of application where one applies for the contract of employment to be reinstated in effect pending the determination of one's complaint for unfair dismissal. And if the court looks at the bottom of page 13 of 18 in section 1281A, it's only in those cases where the reason that's being alleged is one of those specified in those sections, which if I can summarise them because they're not in the bundle. Section 101A and B refer to health and safety, so where a person is discharging health and safety functions and they claim that they were unfairly dismissed for doing that. Section 101A subsection D is to do with being a workforce representative in connection with the working time regulations. The remaining categories are essentially where one's acting as some sort of employee representative, if I can summarise in that way. The first one refers to working time regulations. 102.1 refers to trustees of occupational pension schemes. 103 are employee representatives. And 103A is what's popularly called whistleblowing protection, to use the language of the Act, protected disclosures. And then over the page one has the trade union provisions. So they're fairly narrow, and as I said, it's broadly if one's acting in some way as an employee or trade union representative, or to do with health and safety, or in connection with pensions, or claims to have been a victim of who was a whistleblower and has been sacked for that. In those narrow circumstances, you can apply to the tribunal for interim relief. The deadline in subsection 2 provides that such applications must be presented to the tribunal before the end of the period of 7 days, immediately following the effective date of termination.
And that's not extendable, is it?
Well, that was the point I was going to draw to the court's attention to make sure that you were aware of that. It's not extendable. And so I do accept that there would appear to be a potential for a practical problem in these cases if there is a significant delay between the letter being sent and the letter being received. Well, I'll deal with my submissions on that now, I think, if that's convenient. The first point to bear in mind, and I apologise for this is not in the bundle, but it's a matter of which the court can take judicial notice because it's published statistics from the Employment Tribunal. In the last year, for which statistics are available, 2009-2010, there were 140 applications for interim relief. That's rounded to the nearest 10 according to the Employment Tribunal Service. We made a specific inquiry.
Yes.
So I should correct what I said. I'm not entirely sure, I should say, that the figure of 140 is published. We made a specific inquiry of the Employment Tribunal Service. If the court would like us to confirm that in writing, I'd be very happy to do so. What is published is that in that year there were a total of 236,100 claims. And so with the assistance of my calculator, I make that 0.06% of all applications to the Employment Tribunal in the last year for which statistics are available. The year before that it was 92 out of 151,000, which again is 0.06%.
So just give that figure again, please.
92 applications for interim relief out of a total of 151,000 claims.
151,000?
That's right, my lord. And that also equals, to the nearest hundredth, 0.06%. And the year before that, which is the last year for which I have figures to give you, it was 62 out of 189,300, or 0.03%.
But from the point of view of the individual whistleblower, rather important to get the timing right.
Of course. My lord, I quite agree. I can't pretend that this is not something that would give you, that ought not to give you pause for thought. And I think ultimately the answer has to be that if I'm otherwise right, if one left section 128 out, pretended it didn't exist, and the court was otherwise minded to accept my argument and persuaded that my submissions are correct, then the existence of section 128 is not enough in my submission to cause you to come to any different conclusion. That is so as a matter of principle and practice, bearing in mind that these claims on any view, notwithstanding the importance of the individuals, represent a very tiny percentage of the total number of claims.
That suggests that one should approach the construction of Section 97 in isolation from Section 128. Is the better approach not that you should consider both sections together to gain an insight into what Parliament intended?
Well, I'm not sure that approach is as much assistance as doing it the way I suggested, which is to consider the matter leaving out Section 128 first of all. For the main reason that, as I said, statistically these figures are tiny, and if one's looking at the Act as a whole, this is a provision that, on any view, does not make up a significant part of the scheme as a whole. And so it's, to use a phrase, if I may, it's a question of to what extent one allows the tail to wag the dog.
I follow that, but Section 128 can only work when the employee knows that he's purportedly been dismissed.
Well,
Let's hypothesize, because he can hardly make an interim application without knowing what's happened.
That's right. I accept that, my lord. And as I said, I'm not going to try and shy away from this as something that is relevant, but I think at the same time it has to be seen in its proper context.
It is a feature of the Act, though, that so far, at least we've seen neutral provision 119, a particular example of that, where neither side is disadvantaged. You simply need to establish what the period is and then make the calculation. And then we get section 113, subsection 3, and we look at 128. These are the time limit examples, which are effectively telling the employee that he must do something within a given time. Is there anything that's, as it were, directed to the employer that he must do things within a given time? Or are the really critical provisions all putting the burden on the employee?
Well, I think in terms of the mentions of effective date of termination in the statute, none of them require the employer to do anything by a particular time. The only one I can think of is the provision that says the employer is obliged to provide a written statement of reasons, for example.
Yes.
I don't think that's quite what...
No, it isn't really.
No,
and let's take your point that the contractual situation is on one side. We're not dealing with things like the right to payment of wages or salary. But otherwise, would it be wrong, or is it right to take it as a feature of these provisions that the ones that are actually telling people to do things within given times are directed at the employee and not the employer?
In the two most important respects, which is section 111, the claim for unfair dismissal, and here section 128, yes, correct. And the other important provision, there's three. I'm trying to make clear there's three out of all of these that are important. The other one being the qualifying period for employment is not really directed so much at either party.
That's 118. 108.
108.
Yes.
Exactly, my
Yes.
lord. But yes, I think that probably is fair that in section 111 and 128 they are directed at the employee in the same way that none of these are quite directed at the employer.
Do we get anything out of Part 11? Because there are some references, there's an equivalent definition, I think, in Part 11 of the Act, isn't there? And is it section 145, 162?
Yes. My lord, those relate to the calculation of redundancy payments. And I hope I'm summarising it accurately by saying they're intended to broadly mirror the basic award for unfair dismissal.
Yes. So they're calculation provisions, basically.
It's a calculation provision,
Yes, I see.
exactly, my lord. So there is nothing, what I was going to say is there's nothing more of substance in my submission after section 128. I've listed the other mention in part 11, but that's a calculation provision as my lord says. So we're left, as I said, with sections 108, 111 and 128 as being the ones where this really matters, or matters the most. But the final thing to say about section 128 is that, of course, it is a matter that Parliament could correct in the light of this court's decision. It will not be the first time, of course, that this court has handed down a decision that either has revealed some legislative loophole or highlighted the need for further legislation.
That's the sort of argument that cuts both ways, though, doesn't it? Because this has been the rule that you're attacking has been around for 30 years, and Parliament has had ample opportunity, were there evidence of widespread disadvantage for employers, to correct it.
Well, I was going to come on to that, although it's not in the bundle, I have in mind as perhaps the most the clear recent example in the employment field was the decision of which only my Lady Hell was in the court of Malcolm and Lewisham, where the disability discrimination definition in the 1995 Act and the decision in Clark and Novacold had stood and in fact had been legislated further by Parliament on the basis of it meaning one thing. That didn't stop this court, although my lady dissented on this point, from saying that nonetheless it was not correct and could not be upheld. The particular point that one of the things that was mentioned, I don't want to, the decision's not before this court, but one of the things that was mentioned in that case was that, as was said by Lord Justice Lloyd in this case, is the point hadn't come to this court before.
But it's quite interesting that it hasn't.
Well, my lady,
This particular one.
Can I make some?
I don't want to take
briefly?
you off your course. If you're going to deal with this later on, please do.
I can mention it very briefly now and perhaps come back to it later, because it's a practical matter that arises also out of something Lord Justice Mummery said, because one of the reasons he said is I don't see any problem with this. And one would expect that, or at least in the absence of such evidence, there is no good reason to change it. But one has to look at the reality of employment tribunal claims. Very few of them get out of the Employment Appeal Tribunal. It's something of a surprise, if I may say so, that this case has come this far to me, because these points simply just don't normally get this far. In terms of employers and employees, there being enough at stake or for some other reason pursuing it. So,
But the reason that it has is your clients having appealed, not only from the Employment Tribunal to the EAT, but from the EAT to the Court of Appeal and now to this court.
that's right.
So if there had been widespread discontent in the employer community for the last 30 years, they could have behaved as you have behaved.
Well, I think that's right, but even discontented employers have practical limits, my lady. We did wonder, and it was alluded to in the application for permission to this court, whether the court would be assisted by any sort of evidence as to practical difficulties, and both because there was no indication received from the court and independently of that, we thought that it would not be appropriate. We may well have been wrong to form that judgment, but that was the judgment that was formed. You don't have any evidence about it. Personally, it has been mentioned as a result of this case in the Court of Appeal. Other practitioners in the field have said that it does cause problems in practice, but I appreciate that's something that you can't really take any account of because it's not in the form of proper evidence before you, and I'm sure if the respondent were here, then they would be arguing against me very strongly and saying you can't just make observations like that without the evidence to back it up. But my submission is that this is a point that very often will begin and end in the employment tribunal. But even that is enough in my submission to justify the description causing uncertainty and inconvenience to employers, as well as, if I may say so and repeat my submission, to employees. It's not a rule that requires employees to come to the employment tribunal before they know whether they can bring their claim. is not in their interests, in my submission, any more than it's in the interests of employers. And so, in my submission, you don't need any evidence to take into consideration, as part of your reasoning on this, the fact that certainty is more desirable than uncertainty.
Well, let's assume and take the point you were making earlier, that there's an imbalance between the rules applied to employers and employees. Nevertheless, if you're looking at the employee rule, it seems to be a feature of the way the tribunals have been working that they've been following Brown all the way through. I mean, we do have other cases, I can't give a particular example, where one finds that the tribunals are in some disarray because different EATs will form a different view, and then something has to be done at Court of Appeal level or possibly above to sort the disagreement out. But we're not facing that kind of problem here.
Not so far as claims by employees for unfair dismissal where they say that they received a letter by post and read it on a certain date.
Yes.
That's correct, my lord, but just at risk of repetition, if one broadens only slightly the field of inquiry to consider employees who are themselves resigning, as we've seen in Potter and George, there are different rules there. Yeah. And insofar as one looks at the general principles more widely, for example, the Clark and Radetzky cases, one can see that there is some, at the very least, tension, if not outright conflict. It may well be, Radetzky may well be one of those cases where, unfortunately, the right cases weren't cited to the Court of Appeal, the argument wasn't put in the right way. I simply don't know. But for whatever reason, Radetzky has produced a decision of the Court of Appeal, and they were unanimous on this point, although they were split on the remedy, that Mr. Radetzky's employment came to an end for the purposes that we're looking at here, Section 97, for bringing his claim for unfair dismissal, on a date up to 2 weeks before he knew about it. That wasn't a case about pay or benefits or anything else. It was a question about whether his claim was in time. So it may only be that the real confusion is going to start now that there are two Court of Appeal decisions. If the decision in this case remains, or if it hadn't been appealed, you'd have the decision in this case of the Court of Appeal, and you'd have the decision in Radetzky, and there may well be, well, in my submission, there will be plenty of scope for argument about how those two could or should be reconciled.
Yes. Well, I was inviting you to explore the statute. I think we've completed that chapter, haven't we?
Yes, my lord, I think the only other, which is not really relevant, purely for completeness, at tab 2, the effective date of termination is often used for amendments to the legislative scheme.
Yes.
That's the other place in which the phrase comes up in the law, if I can just put it in that very, very broad way, although I don't think that assists. My lord, perhaps what it would be convenient to do next then is to just look very briefly at the case of Brown and McMaster, particularly in light of the exchange we just had about the rule that's been applied consistently for 30 years without any difficulties. The decision of Brown is at, well, it should be at tab 5. It may be in tab 4 in your bundle. My apologies, I think there may have been a slight filing error there. It should be in tabs 4 or 5.
Well, in my file it's 4.
Yes, it's listed in the index as 5, but I found it in mine in 4. I've moved mine so it matches the index, but I don't think it's going to cause. My lord, in that decision at page 628, I accept that there is a clear ratio of this case. It's best expressed at letter G, as set out in my written case. The termination does not take effect until the employee has either been told of or has had a reasonable opportunity of reading the notice of dismissal. It's put very, very slightly differently between letters B and C just above that. In our judgment, the employer who sends a letter terminating a man's employment summarily must show that the employee has actually read the letter or, at any rate, had a reasonable opportunity of reading it. Maybe worth just noting very briefly what follows that, because it's returned to in McMaster. If the addressee of the letter, the employee, deliberately does not open it or goes away to avoid reading it, he might well be debarred from saying that notice of his dismissal had not been given to him. That, however, did not happen on this case.
The word told, just above G, must be told by letter and therefore reading, isn't it? I mean, that's just what's said in the next sentence. So there isn't really a difference between these two formulations.
No, I don't suggest there is, my lord. However, if one looks, unless there's anything else specifically on that, if one turns to tab 13 in the McMaster decision, there is not quite such a clear ratio to be discerned. It is, of course, right, I don't suggest that they are not broadly consistent, and they're often bracketed together. But it's a decision which is really, the AT is concentrating very much on the facts without trying to lay down any principles. But perhaps the relevant part to start in this report is on the second page in paragraph 9 in the bottom right-hand corner. Beginning, it seems to us that. And this is what I was referring to in my submissions, saying that this idea that constructive or presumed knowledge must be shied away from in the employment field and has no place is flawed from the outset.
Well, the contrast is between the service of formal documents, and everybody knows the rules are quite specific in their case, and what he's dealing with private rights of parties to a private contract. So, I mean, that isn't really controversial, is it?
That distinction is not, my lord. Your Lordship will recall that I've included in the bundle for your benefit the provisions in the CPR which deal with those particular rules, and I have made the observation in my written case that if one had that, one would at least have the benefit of absolute certainty, although it's not necessarily an outcome for which I'm...
Yes, well, the statute hasn't followed that line, has it?
Well, no, my lord, but as I've said, that in my submission, Parliament has left it open
Yes.
to the courts to say what it means.
Right.
I can see some difficulties with importing the CPR rules into that context. Absolutely.
But Brown is taken as the guiding authority anyway, isn't it?
That's right.
Yeah. And is there any reference to court, Mr. Justice Brown Wilkinson's formulation? It doesn't come up in this case.
In McMaster, no, there isn't. Well, the only point to draw out of that, on paragraph 9, if the court's read that paragraph, is that it appears, and certainly I've not put this in, it's a matter of interpretation, but certainly the editors of Harvey, which is the leading encyclopedia on employment law, suggests that this is a narrower, this formulation here implies a narrower approach, because it appears to make clear that unless those two examples given in Brown represent the only two examples in which an employee will be, to use the words in Brown, debarred from saying that he or she has not read the letter. They were given as examples, and the way it's put here tends to suggest that only those will do. And the only observation I make about that is that there's a slight degree of artificiality about that, because an employee who deliberately closes his or her eyes to a letter, the reason they're doing that is almost certainly because they know, or they think they know, that they've been dismissed and don't want to have the black and white evidence in front of their eyes. So insofar as one's talking about communication of knowledge or the fact of dismissal, they more or less, in effect, do know by not reading the letter, or that's the underlying assumption. So it's not really much of an exception. But in any event, what one can see about this rule is that it is, for want of a better way of putting it, it's a sui generis rule that was developed by the EAT. When I say sui generis, I mean that it's not the expression of any ordinary contractual principle.
Yeah.
It's more or less being invented for the purposes of Section 97.
But if one goes back to Brown, the formulation there would cope with the kind of situation you're envisaging, where the employee just simply doesn't want to face up to the letter, as you say, knows perfectly well, but just can't face seeing it in black and white, and therefore just chucks the letter to one side and just assumes that the worst has happened, doesn't read it. Not deliberately evading, but just simply not wanting to look at it. But that would be covered by having a reasonable opportunity of reading it.
Yes.
The letter's in her hand or his hand, and,
Yes.
and so on.
Yes.
So the Brown rule is all right on that view. Your criticism of Master is perhaps it goes a bit too far.
Well, yes, my lord. It's a fairly small criticism in the scheme of things. My main criticism is about the two cases generally, the principle that they establish, this sui generis rule.
Yes.
I was simply making the observation that McMaster is not entirely clear what the ratio is, but it appears to suggest that those two named examples of deliberately shutting your eyes or going away are the only circumstances, whereas in Brown they were given as examples only. Well, the other practical matter that perhaps I didn't indicate earlier, but in relation to the exchange that's just taken place about an employee shutting their eyes to the letter and putting it to one side. Of course, when one thinks about this in practical terms, unless one as an employee is on holiday or ill, most people work at least 1 or 2 days per week. So within a matter of days, it will become immediately apparent whether or not you're sacked, because you're supposed to turn up in the office and go in, and either you will make the decision yourself whether to turn up at 9 o'clock in the morning if one has a job that starts at that time, or your employer will phone you up to say, why aren't you in here? We didn't sack you last week. We're expecting you at your desk doing your work. But in my estimation, that's another important practical consideration to bear in mind, so that one doesn't proceed on the basis that there is some sort of, one has to adapt this rule to suit or to take account of a rather fanciful situation where an employee is stuck in limbo with no way of finding out whether or not they're supposed to be going to work in the morning, to put it at its lowest. Now, well, I don't think, well, perhaps it's an expression of hope, but I'm very happy to deal with it, that this rule is inconsistent with what one might call ordinary contractual principles is not really in dispute. It appears to have been accepted by the Court of Appeal, but by the majority of the Court of Appeal, that contractually a different answer is produced, or this principle in Brown is not an ordinary principle of contractual law.
Yes, I think that comes through very clearly through the reasoning of Lord Justice Mummery, that this is a particular situation of a private contract of a personal nature.
Yes.
And therefore you can distinguish charter parties and similar cases of that kind where one would find the hard-edged contractual rule being applied And he says, well, that isn't a proper guide to what this rather special statutory construct is dealing with.
Well, yes, my lord, but if I'm, even if it's not necessary to go into detail, it is an important part of my submissions that if that is right, as I say it is, and appears to be accepted, that the contractual analysis would produce a different result, then that must be the starting point. It must be the starting point because employment law is generally, in general terms, governed by contractual principles. So it forms the basis of it in terms of the formation of contract of employment, construing the terms.
Well, to a significant degree, I agree, but employment contracts are different from the ordinary run of contract in the sense that the employer can unilaterally bring the contract to an end, as opposed to the more general rule of contract that a repudiation must be accepted.
Well, my lord, that more general principle that a repudiation must be accepted is, of course, right, stated that way as a principle. But when one thinks about any other ordinary contract in practice, there will be many cases where there is no option but to accept the repudiation. So, to use the example given by Lord Denning in the Clark case, the opera singer who doesn't turn up to perform. There can be no question of affirmation of the contract in any meaningful sense in those cases. And of course, in the case of Vitol, which is in the bundle, then acceptance of repudiation might be signified by doing nothing more than continuing to perform your side of the bargain. So, with the greatest respect, I think it's just, that's absolutely right as a statement of principle, but as a matter of practice, it doesn't necessarily make much difference in the employment context is the same as in non-employment contracts in terms of what the options of the wronged party are. An employee does have the option of accepting certain repudiations, and that's where the doctrine of constructive dismissal comes in. So if an employer behaves in a way so as to breach the fundamental terms of the contract, such as the implied term of mutual trust and confidence, by acting in a way that is incompatible with that, the employee has a choice, and that's central to the doctrine of constructive dismissal. Indeed, if the employee doesn't accept it and go within a reasonable time, then he or she will have been found to have waived the breach or not accepted the repudiation. So one can go to an employer and say, I'm not very happy about what you've done, but I want to carry on working for you and I want to put it right. Or equally, they can say, that's it, I'm off. So in practical terms, my submission would be that there's not an enormous difference between the two. But in general terms, in any event, the principle that employment law is underpinned by principles of contract law, I think, must be uncontroversial.
Well, there is a contract of employment.
There is a contract of employment.
I'm not sure that takes us very far, because the contract of employment may say one thing, and the actual statutory regime may say, or add to that, or vary it, as it does in quite a lot of respects.
I agree, my lady, but my submission is why this is the correct starting point. It only makes sense to start with ordinary contractual principles in my submission.
The starting point when an employer decides to dismiss an employee must be a step further than when the employer makes that decision. There must be some form of communication. I mean, if the employer decides privately that the employee must go, that doesn't have any legal effect, does it, at that moment?
It's not quite that simple, I would submit, my lord. First of all, it depends what one means by communicate.
Well, communicate, I agree, was not a very good word. But an employer decides, perhaps talking to his co-directors, this employee must go immediately. And that's all that happens. The contract of employment, whether common law or for any other reason, doesn't end at that moment, does it?
Well, I think if that's all that happens, my lord, I think I would have to accept that. But what I have in mind, in answer to your lordship's point, is the situation in Radetzky, where what the employer did was to stop the employee's pay at the end of October. The decision was effectively taken internally. We can look at the facts if necessary, but the decision was taken internally that Mr. Radetzky's employment was at an end. So his pay, the instruction to stop his pay was processed by the payroll department. A P45, the process of preparing that began, although I don't think he got it until later. And nonetheless, it was found, and it may well be that this court's going to say that it was wrongly determined, but it was certainly found in that case that nonetheless is effective date of termination for the purposes of the same provision we're looking at here, was when the employer did that. And if one takes it a step further and looks, for example, at the question of Clark, yes, there was a letter written, so the employer did do some external act by sending out from its offices a communication in the form of a letter, but there was no finding or even inquiry as to who that was received by, when it was received, whether it ever came to the attention. Clark is a difficult case because the Court of Appeal thought the facts were quite appalling, of someone just taking off on holiday without telling their employer. But this is if I can just remind the court of the submission made in my written case, it may just be necessary to note the reference rather than turn it up. Paragraph 47, where I've submitted that the real issue on Lord Justice Lloyd's approach, and this is in the discussion, the part of my written case where I consider whether the date should be the date of posting or the date of delivery, which we don't mind about how you resolve that because we win either way if we get to that. But whether the parts of the law's expectation of what the terminating party should do includes ensuring delivery, that may not be considered an unreasonable expectation, but it has to be recognised that it does have the effect of preventing an employer or employee from terminating unless and until such delivery is achieved. And there may be very good reasons, again, if one looks at this in a balanced way from the perspective of employees as well as employers, where they do want or need to effect a termination for very good reasons or for reasons of their own. And it is not at all obvious why the law should impose a rule that prevents them from doing that unless and until they can ensure that their resignation has actually been received by the employer. The most obvious example, which was referred to in my written case, is an employee resigning over the weekend, where it may be very important to do that. But again, if one considers, as I said at the outset, the potential factual variations for who an employer is and what size they are, what resources they have at their disposal, and the employee, show that there may be cases where an employer may be a single person who himself or herself is away on holiday. And nonetheless, the employee is very anxious to go and work for another company or doesn't want matters to be reported to the regulatory authorities, as was the case in Potter. Well, these are all just examples to illustrate that not only is there nothing controversial in principle about this concept of termination without the other party knowing, there are also good practical reasons why a rule that prevents that would not be necessarily advantageous or helpful. If I may say so, the risk of sounding perhaps slightly grandiose about it, the contractual principles that have been developed by the common law have the beauties of the common law system, that they've grown over time, taking account in the accumulation of cases of all of these considerations. That doesn't mean, of course, I don't offer that as a reason why you must follow them, but they're not an arbitrary set of rules.
How many common law cases are there on the method of communicating the acceptance of a repudiatory breach by the employee of an employment contract? There aren't any, are there?
I don't think there are.
No.
I don't think there are.
So, in fact, this allegedly absolutely cast iron common law rule is developed in the commercial context. In fact, shipping context.
Certainly the Brimners is. Yes, but I mean, I agree, and that's why I'm not trying to overstate this submission. I'm not saying that because it's obviously right for charter parties and shipping agents with all the sophistication that implies, it's necessarily the right approach in the employment context. But it's not, in my submission, limited to that. These are principles that apply not just to shipping cases, but to all other contracts apart from contracts of employment. So,
are you going to take us to Kirklees and Clark? Because it's just listening to what you've just been submitting, I was just wondering whether, supposing Brown had come up for decision now against the background of those cases, your submission would be that Mr. Justice Slynn would have taken a different view. I mean, is there guidance? I mean, I'm just looking, for example, I think it's tab 10, Lord Justice Ricks does say in paragraph 49, the effective date of termination will be the date of summary dismissal as long as that is known to the employee. So he does take that as a necessary requirement.
well, of course he says that there, but what one can't escape from, and it may be that this manifests itself as a criticism of Lord Justice Ricks, I don't intend it as that, but what one can't escape from is that a few paragraphs later, he upholds the finding that there was an effective date of termination, notwithstanding, it's paragraph 56, it's the third sentence, whether rightly or wrongly, Kirklees had terminated Mr. Radetzky's employment by the 31st of October 2006. Mr. Radetzky knew that within the fortnight. Now, being as generous as one can, I think the reason why there might be this tension is because it didn't make any difference, I don't think, whether it was the end of October or the middle of November.
Well, that's right, and
He
that's
was
the
still-
problem with this case, isn't it?
He was still out of time. So it may
Yes.
be, this is not my submission, but I'm trying to be as balanced as I can, is that this is just infelicitous or unguarded use of language. But I think my submission that that's not the case has some force, because we are talking about the Court of Appeal, who cited, as my Lord has said in paragraph 49, were quite aware, apparently, on one view of the principle. At paragraph 49, the effective date of termination will be the date of summary dismissal as long as that is known to the employee. And it may be that this was a more deliberate departure from that, because the facts of the case were such that they recognised that the right answer on this case, although for reasons which I accept are not as helpfully articulated as this court may like, in the same way as Clark, it was the right decision about when the EDT was. I am slightly handicapped in the submissions I can make by the observation that my Lord has just made about what it says.
Well, I take it that he'd obviously been looking at court amongst other cases, and I take it he's based that remark in paragraph 49 on what he finds in that case.
Yes.
But you're quite entitled to point out there's a bit of a drift when you get to paragraph 56.
Well, that's right. And again, even as it's stated in paragraph 49, that is simply not right as an absolute principle, because as I said at the outset, Brown itself admits of the possibility of an employee being dismissed.
Yes.
And whilst, as I said, McMaster suggests it's narrower, certainly back in 1980 when Mr. Justice Slynn, as he then was, gave that judgment, he may well have been contemplating, or at least his judgment leaves open, to a tribunal to be more robust about it and say, I'm very sorry that you had a reasonable opportunity on day 4, say, to find out, and you didn't take it, and so I hold that to be the EDT, notwithstanding that you didn't shut your eyes to it or you didn't run away from it. And similarly, I wasn't at this stage proposing to go in any more detail through Radetzky because there is not much more there to provide real assistance. I've set out the key facts which make clear what the factual findings were, and I've pointed out the inconsistency. I don't even think we need to turn to Clark. The similar point I'd make about that is, regardless of what assistance you get from the legal principles, it does provide, at the very least, a concrete practical example of a situation where it would simply be wrong, in my submission, for practical reasons as well as reasons of legal principle, to find that Mr. Clark was not dismissed until he'd had a reasonable opportunity of reading the letter. He simply took off. They wrote to him trying to say, when are you coming back? And there was no reply. And so they took his name off the books. And as I've said in my written case, that is entirely consistent with orthodox principles of contract law. It's an unequivocal act. As it's described, perhaps I should have just highlighted, though it's in my written case, in the Radetzky case, the Kirklees case, Lord Justice Toulson, in a very short judgment, refers to ceasing to pay his salary from the 31st of October as the last vestige of any performance of the contract. Paragraph 47.
There were
But
letters.
it also refers to what Mr. Radetzky knew.
Yes.
Ceasing to pay his salary, which they'd indicated they would do, and which Mr. Radetzky knew that they had done when the payment ceased to come into his bank account.
But not on the 31st of October, Melody. That's
But we've already accepted that it would have made no difference.
It could have made a difference, yes.
If it had made a difference, these judgments might have been expressed differently, might have been expressed the same. We can't know.
No. I'm drifting in these submissions into the second part, not the narrower issue, but into the second part of the case where I say, if Brown is wrong, what should you replace it with? What should this court replace it with? And as I've made quite clear, if I get to that stage with this court, then it doesn't matter so far as this appeal is concerned, because we win. Because whether the effective date of termination is the date that we posted the letter, or the date that it was delivered, or even the deemed date of delivery under the CPR, then the claim was out of time.
Yeah.
That's... So anything I say about which should be chosen between those two, as it were, comes with that caveat that it doesn't... I'm trying to assist the court rather than advance my client's case, because the order that we seek from this court is an order that the appeal be allowed, and we're entitled.
There are these various options. Date of posting, particularly looking at that rather awkward section, or section 128, would seem to be rather harsh, really, because of the delays one knows elapse in the ordinary postage system. It may be 2 days go by before it arrives, and then there's always a risk it may not be picked up that day because the chap's gone out and the post arrives late and all that kind of thing. So 3 days have gone by, and so on and so on. So date of posting doesn't really work. So you're really coming to date of delivery or reading, or a reasonable opportunity to read.
Well, the only very brief submission I'll make in response to that is, insofar as one's talking about practical considerations, I entirely agree about what was said about section 128. One can see those. I would simply remind, my Lord, that what I said about if as a matter of principle that is right, then it's a question as to what extent the practical consideration should be allowed to dictate practical consideration relating to section 128 and 0.06% of the cases
Yes, yes.
should be allowed to dictate a different result. But I entirely accept that, and if to succeed in this appeal I had to persuade this court of that, then I accept I'd have a much harder job on my hands. All I say about that is that it's perfectly consistent with principle, and leaving aside section 128, it doesn't cause any problems in practice. And in fact, it makes it very slightly easier in practice because one has, assuming the word processing, as my Lady Howe said, hasn't gone wrong, one has a date on the letter. And of course, there is an irony in this case, as well as in the Radetzky case and in the Potter case, that the employee put on their claim form in each of those three cases the date that the employer was contending for.
So she looks at the date in the letter and puts it in her form.
Well, that's right. And I think the importance of that, it's not just an irony to notice, the importance of that, again, is when one's considering how will the ordinary employee understand these matters, that is as good an indication as any of how employees very often will understand these matters. The date of the letter was the date their employment came to an end. The reason? Because it's not of enormous practical importance, except for the purpose we're discussing, whether to argue that it was a day or two later. This comes up when they leave everything, or the representatives leave everything till the last minute, and then come along to the employment tribunal to argue, because all of a sudden it matters, because it's gone in a day or two or more late.
One can understand the difference between the date that's put in the letter as the date when the contract ended and one is back into the field of contract. And then this curious word, effective date of termination. The statute doesn't just say date of termination, does it? It's got the word effective in it, which is a curious injection of an adjective, which one wouldn't normally use, and it's there for some purpose.
Well, it's defined as when the termination takes effect, so yes. Well, that's right, my lord. And then one's left with the question that they're pondering as to exactly what that means. But just to remind the court of my key submission on an employer who sends a letter, and for example, I wouldn't accept it's necessary, but it will almost, I would submit, be the case, stops pay on that date. And I've listed some other examples in my written case, trying to think of practical examples from the world of work. It's highly likely that once an employer has made the decision to sack someone, particularly in gross misconduct cases, where they're anticipating not having a positive relationship after the termination, they will do things like cancelling a swipe card if there's security access to the building. They are likely to cancel their access to the employer's computer networks. They are likely to insist immediately upon the return of all property that belongs to the company in possession of the employee. Where is a happy termination, if I can just use that general, then the situation may well be different. But very often in these cases, the guillotine comes down in every respect. On the day the employer makes the decision. These are all, to borrow the language from orthodox contractual law, they're unequivocal, overt acts.
Well, they're overt if they're overt in the sense that others may know what the employer is doing. They're objectively verifiable. Nevertheless, they will normally, as you have already pointed out, come to the attention of the employee the moment he turns up for work.
Well, that's right, my lady, but I think it must be the case that in the principle that I'm referring to that's set out in Chitty and is taken from another shipping case, unequivocal overt act must mean the former, i.e. something that's objectively verifiable could be seen, rather than any requirement that it is in fact seen, because that's otherwise it doesn't make any sense to have that as a principle, because you're going back to saying, well, it's got to be communicated somehow. And the whole point of this rule is to say that you don't always have to manifest your intent. I'm simply using the wording as set out in paragraph 15 of my written case, without any concurrent manifestation of intent directed to the other party. I mean, in actual fact, in these cases, there is manifestation of intent directed to the other party, but what it doesn't require is that intent reach the conscious mind of the employee or the other party to the contract. The fact is you've done it, you've made your decision, it's unequivocal, it's overt. It's not, to go back to my Lord Savile's example of the managing director saying, for example, to his secretary who might be typing the letter, the person's sacked. That is entirely internal at that point. So that's why I accepted that that on its own would not be enough. But I don't want to dwell on this point because I said it may well be that the court's not with me on it and it doesn't matter. But I think what it is important to appreciate is that is an entirely sustainable and defensible principle to have as a matter of contract law, and in an employment context, it's entirely practical. The only practical downside to it that I can see is section 128.
What is your basic submission if one were to apply what you describe as the ordinary law of contract? The posting of a letter or the delivery of the letter?
I think, my lord, the answer to that is that the strictest interpretation of the contractual principles would be the posting of the letter, because it may depend upon what else is done. If the employer posted the letter but, for example, didn't stop pay or didn't cancel the swipe cards or the other examples, then there might be some ambiguity in what the employer's done. But if, when one looks at the situation, the employer has done everything that he or she or the company could reasonably do to bring the contract of employment to an end, then there is nothing more that they can be required to do. So if any challenge is made to them saying, you have not terminated my contract of employment, the only answer they could give is, what more could I have done?
That would apply to the address too, would it? So you would say that the employer has done everything that he could be said reasonably, that he reasonably ought to have done if he has posted a letter to an address which he reasonably believes is the right address. And that's it. Even if in fact the address is the wrong address, so long as he had reasonable grounds of believing it was the right address, that would be good enough.
My submission, yes.
Yes. So the corollary of your submission is that the employer doesn't terminate the employment if he sends it to an address in respect of which he has no reasonable grounds for believing it is the correct address.
Well, that's right, my lord. And I deal with this in paragraph 46 of my, or paragraphs 45 and 46 of my written judgment. And perhaps I should say before dealing with those specifically, is that there may be scope for a dispute about these, because I say there's a clear contractual principle. It doesn't mean that this application to any one set of facts produces a clear and obvious answer. I accept that.
Well, that was why I was asking you about different contexts.
Yes.
Different.
Well, yes. But as I said in my written case, paragraphs 45 and 46, is if the employer or employee, because I've been very careful in these submissions, as I submit the court must be, to test these things from both perspectives, knows that the other party is not at the relevant address at the time when the letter might be expected to be delivered, or checking a fax machine, or checking an email account, or checking one's answering machine. So examples of this would be a dismissal letter posted to an employee known to be on holiday, or a letter of resignation faxed on a Saturday morning to an office that is only open from Monday to Friday. But what I say is those are addressed by Lord Justice Lloyd's subsequent consideration of whether the employer has done everything that can be expected of him to terminate the employment. Now that language is not dissimilar at all to the language used in the Brimners.
But just going back to your paragraph 45, if the test is when the letter is posted, why does it matter when it's likely to be delivered?
Because, my lord, if one adopts as the test, and as I said, this is what Lord Justice Edmund Davis posed in the Brimlets as being the rhetorical question: what more can the party reasonably be expected to do? If the employer knows that the employee has 2 addresses and that he will be at address 2 when the letter that he posts will be received, and he addresses the letter instead to address 1, then there is, in my submission, obvious scope for the submission that the employer did not do everything that could reasonably be expected, because he knew the employee was at address 2, and therefore he should bear the consequences of the termination not taking effect, because he hasn't done everything. I follow that, but the difficulty I have in my mind at the moment on the suggestion it's the date of posting, which is the effective date of termination. If that's to be taken as the correct date, why does when it's going to be received matter? Well, my Lord, in a sense it doesn't. But when one's testing the legal principle as to whether or not an employer should be allowed to say, your employment was ended as of today, day 1, because on day 1 I have done everything that I could reasonably expect it to do to bring your contract of employment to an end, the employee may have an obvious riposte to that, which is, no, you didn't. You posted it to address number 2 when you knew I was at address number 1.
But it wouldn't matter where you posted it if all you had to do was... if it didn't matter whether or not it was likely to get to the employee. Well, I think that's what's behind my Lord's question.
I accept that entirely. I think we may be at slight cross purposes, because the purpose, I understand from the question that you're concerned about the practicalities of it, and I accept that in practice it makes no difference. My submission is about whether or not the application of the principle to those facts, what's the correct principle to be applied is, and if the principle is to ask, has the employer done everything that he can reasonably be expected to do, if that is the answer, as Lord Justice Lloyd said, or implied, that is a relevant consideration, then that may produce different answers depending upon the different facts of each case, even though practically the situation may not be enormously different, because the employee still doesn't know about it. I follow the proposition, I'm not saying I accept it for one moment, but I follow the proposition that the employer must do everything that it is reasonable for him to do. And if he posts a letter to an address which he has reasonable grounds for believing is the correct address, then I can see it can be said the employer has done everything that can reasonably be expected of him to do. But then, assume that's right, what is it that the employer is doing? And the employer is doing everything that's reasonably expected of him to do to bring notice of the termination to the employee. But then surely on that logic, the date of termination is when it might be reasonably supposed that the employee gets and reads the letter, or gets the letter. That may well be the very issue to be determined, and I say that final stage is not... Otherwise, what's the point of the employer writing the letter at all? Surely the point of writing the letter at all is to tell the employee he's dismissed. Yes. Well, that is the question as to whether or not, if there be a different test from Brown, it be limited to the principle that my Lord has just enunciated, or whether to the end of it must be added, as Lord Justice Lloyd did, the final necessary ingredient that the employer, none of that will it all counts for naught unless the letter is actually received. So the way I put it in paragraph 47 is part of the law's expectation of what the terminating party should do. Does that include ensuring delivery? Or is that an obligation too far on the terminating party?
I wonder whether we should explore that a little more after the short adjournment. Is that a convenient point at which to raise? Well, we look forward to seeing you again at 2:00.